Hi there, you're with DQ Prime, and this is the Fine Print. We are discussing the Digital Personal Data Protection Bill 2023, which the government introduced in the Lok Sabha today. What does this newest version of the privacy law mean for businesses, citizens of India, and and all the stakeholders in the process? To answer that, I have with me Rahul Matthan, partner at Trilegal. Rahul, welcome to the Fine Print. Yet another show where we are discussing whether this latest version makes the cut to the ideal privacy law that we want for this country and its citizens. Your first high-level assessment of the bill. You've always been an advocate of a principle-based, law. It sort of largely is along those lines. First, your macro view of the version that got tabled today.
So look, yeah, I mean, I've been waiting for this now for over a decade. So I'm.
You've grown old with it, Rahul.
I have grown old with it, and I'm almost afraid to jinx it. But this is close to that principle-based framework that I was hoping that we would have. I mean, I think obviously there are things that I would like to change in this. But if you ask me for a macro view, I think that this is a good legislation to start with. If we compare it to the one that was most recently made public, that is the 2022 draft that we've had the opportunity to look at in some detail, it is slightly different from that. So it's not like a huge change from that. I think some of the changes are new, and I'm a little concerned by some of those changes. But then if you just look at the macro view, what we wanted something simple to start with. We wanted something that would lay down the principles so that a country that's just starting on its data protection journey could, get used to the new impositions on them in a general way, and then layer on top of that complexity as we go down. And I think this gives us a good starting point to do that sort of an approach to building data protection. Just such that we're clear, the contradistinction, the other approach that was in play was going straight to a GDPR style framework, which is very compliance heavy. And I've long maintained that I think that would be difficult for us to do at the current stage of our evolution in data protection. So from that perspective, I'm actually quite happy with the law.
Okay, I don't want to do a spot the difference kind of thing conversation with you between 2022 and this version, but I do want to use that as a reference point to understand some of the changes that have now come in. The one sort of big furor was against the language, which said that in some cases, from consumers' point of view, it would have been a deemed consent scenario where you have voluntarily given information, and the data fiduciary or the person you're giving or entity you're sharing that data with will then use it because you have voluntarily shared it with that entity. It's in some of the examples, if I can point out, you've called a real estate broker, you want a PG accommodation. Now, when that broker then calls you back, you can't, or that broker, that firm calls you back, you can't say you violated my data. Now, that deemed consent, as you read it, is not something that is being done away with. It's just been sort of reworded or rebranded as legitimate purpose. Can you help us understand, what the implications of this changed language are?
Yeah, look, I think when we saw deemed consent in the previous draft, we were a little concerned because it felt like there was like a violation being done on our autonomy. Because we haven't consented, but someone has deemed that we have consented. It feels terrible. It feels like someone is doing for us something which we should have done ourselves. And if you actually read the provisions under deemed consent, if you read the provisions of the law under that heading, that was not what it was doing. And so I think the problem in the last draft was really with the title, and I think that it was an unfortunate choice of words, and I think they've rectified that by moving to something called legitimate uses. Now, the concept of legitimate grounds of processing is a well understood concept around the world. It essentially says that, there are many grounds for processing. Consent is one of those grounds. Another one of those grounds is a legitimate grounds of processing. And it essentially says that when there is a legitimate interest to process the information, that you should be allowed to do that. A classic example is that, if you are being carried into an outpatient department, like after an accident, they may want to actually legitimately process your information, see what your allergies are and things like that, to make sure that they don't give you a medicine that could actually kill you instead of save you. And that's the classic definition of legitimate grounds of processing. And I think that's what they intended. Now, the example that you gave, which is that, if there's a real estate broker to whom you've provided your information, and that person calls you back to tell you, look, you wanted a house and there is a house available. I think that the provision has now been changed to say that in those circumstances, you can't go and sue the real estate broker for using your number to contact you, because you gave it to him in the first place for this purpose. And so that is what 7.1A has now been restricted to say that, look, if you have provided your purpose, your information voluntarily and for a specified purpose, and they process that information for that specified purpose, then you don't have a grounds to say you didn't get my consent, you didn't show me the notice, all of those other things. So it is a fairly narrow interpretation compared to the GDPR interpretation of legitimate grounds of processing, but it actually is intended to deal with those situations. Like, for instance, the other example illustration they give is that you go to a restaurant and you say, you make a reservation at a restaurant and say that when the reservation opens up, please give me a call. And if the guy does call you when the reservation opens up, you can't sue him to say, why did you call me? Because you gave me the number to call you. I've done it for the specified purpose and you voluntarily provided the information. Yeah, I didn't do the whole privacy policy and consent and all of those things, but I shouldn't be punished for doing it. And I think that's the intention there. And I think there's no mention of this concept of deemed consent, which makes it a lot less icky. I think, all of us really we felt violated because someone was consenting on our behalf, and that's not there anymore.
Okay, so Rahul, one is where situations, and we discussed this offline, where I've shared the information, and for a legitimate purpose, that information is getting used. But what you and I probably can safely say you and I both are plagued by in today's environment is places where I've never done business, places where I've never given my personal information, and those entities then sort of calling me, and as they're broadly called, spam called, to offer services, goods, etc., etc. Now, is there anything in this law that says that I, as a consumer, when I'm very sure that I have not shared my information with a bakery, I have never dealt with that bakery, and that bakery is sending me now marketing messages, or a particular financial institution, can I go to the grievous redressal mechanism of this entity and ask them, where did you get my information? And if they fail to give me a legitimate answer, I can take it up with the Data Protection Board?
A simple answer is yes.
And what are the sort of consequences of that might follow?
All the consequences that follow through. So, I mean, I'm sorry to like just give you a simple answer. Yes, but that's exactly what it is.
And I want a simple answer for this, because
it's very simple. Right now, you have to, when you process personal data, you have to process personal data for a specified purpose. You're not allowed to process it for anything other than a specified purpose. You can't contract out of it by saying that, look, you waive your right to only be limited by this specified purpose. So there's many belts and braces in this law, more than the 2022 version as well, which is doubling down on this principle that that you must define the specific purpose for which you're collecting data, and you can only process data for that specified purpose. And then there's another provision which says that the onus is on you to show, if someone is questioning why you have reached out to them, to show that you have actually provided notice and got consent in order to allow you to reach out to that person. So your bakery, for example, if the bakery is reaching out to you and you say, why are you reaching out to me? The onus is on the bakery to say, look, you actually were given notice that this is what I will process this information for, and you consented. And it's only then that the bakery will be able to win in the Data Protection Board or in any grievance redressal process where they are challenged. And so I think that is very, very clear in this law. And what does this mean? I think we must always look to what does this mean to our daily lives. We all know that we are constantly being called by various telemarketers to say, can I sell you this plan, etc. Everyone is going to have to rethink the way they do telemarketing. They're going to need to clearly maintain a record of the consent that's provided and the specific purpose for which it was the consent was provided, to make sure that when they call this person, if they are questioned, they actually have a paper trail to say, yes, I can legitimately call you. A lot of businesses today rely on these sorts of cold calls. I think a lot of those businesses, almost all of those businesses, are going to have to shut down because I don't see any way in which they can function when they are buying lists of just lists of phone numbers and just randomly calling through those lists. There's no way that they can establish these things that the law now requires them to establish.
Okay, that's very heartening and sort of encouraging to hear that as citizens, the law is actually doing something for us. Let me now come to some of the obligations that your clients will have to sort of now look at more closely. And in that, there are an extensive list of obligations for data fiduciaries. Do you want to flag some of the important ones that businesses, companies will now need to prepare for?
I think we went through one, and I think the first one really is this whole sort of chain. When you're now using data, you've got to have in place the processes and the mechanisms to make sure that you can process the data in the way that you're doing with regard to a particular individual. Now, that's actually not an inconsiderable lift because right now we don't have any of those processes in place. And when I advise my clients, I very often tell them, look, these are the types of things that you're going to have to change when you do this. There is now an obligation to provide the notice and consent in all the languages in the schedule. When I say now, it was there in the previous version as well. But the point is that when this law comes into force, the moment it comes into force, anyone can come to you and say, you need to give this to me in a language, one of the languages of the schedule. And if you can't do that, then you're in violation of this law. So companies are going to have to start, now putting in place these mechanisms to have these translations in place so that everyone can understand what is being done with their data. And I think that there are these sorts of additional steps that companies need to take in their internal organization. They're going to need to have to set up data protection office. They're going to have to set up grievance redressal mechanisms. These are the sorts of things that certain types of companies absolutely mandatorily have to do. But it is a new lift. So I think a lot of people keep saying that we comply with GDPR, and so we're okay with all of these things. But I think there are many new ways in which India is requiring companies to operate that they are going to have to look at. There's another I'm going to say strange provision. We mentioned it earlier, which is that you cannot contract out of the obligations in the act. Now, what does that mean for companies? They're going to have to look at their privacy policies, and they're going to have to look to see if there's something that they have put into the privacy policy as something that they wanted in order to be able to perform some of their services, and see if that complies with the provisions of the law. Because if it doesn't comply with the provisions of the law, putting it in the privacy policy is irrelevant because it is invalidated the moment the law comes into force. And now these are things that in many ways go against the way in which companies think right now. The companies think that, look, there is an obligation, but if you and I contractually agree that we will do such and such, the fact that the obligation exists doesn't matter because we've had a private contract in order to get out of that provision of the law. But this legislation actually says you cannot do that.
Yeah, I think one of the examples that, and correct me if I'm wrong, that this bill gives is that if I waive my right to complain to a data protection board,
exactly.
That provision will fall through and will be frowned upon.
Exactly. So you can't say that, I agree that if there's a dispute between us, I will not go to the data protection board. I mean, you can say that if you want, but it makes no difference because they can still go to the data protection board. Now that's, it seems like a silly thing to say, but there are many other subtle things that companies today are doing. They're saying, we agree that this will not apply. You can't do that, and I think that's a real wake up call for companies. I would say that companies will have to take out their privacy policies and whatever their grounds of processing are today, and look at everything that they've got in those privacy policies, compare it to what the provision of the law says, and see whether they can continue to keep it or not. Because a lot of their internal business processes, not just the the data protection related things, but just other business processes depend on these things. And if they want to rely on it, they're going to need to know that at some point in time, if someone complains, then they are not going to be able to follow this thing that's in the contract. They have to go by what's in the law.
Yeah, and also I think in our offline conversation you mentioned the erasure requirement now. That was also sort of concerning for you.
Yeah, so there's always been an erasure provision, and that's there in sort of every data protection law, which essentially
And
says,
also that purpose has been met, kind of condition to be sort of met, right? Before, when you say that I collected your data, now the purpose of that data is being served, and now I have to delete it.
yeah. So I mean, I think that's sort of the way in which it always applies. Let's say you've collected my data. Let's go back to that real estate example. The real estate broker collected my personal data in order to find me a house, found me a house. And now I have the ability to go to that real estate broker and say, please now delete my information because the purpose has been served. Now don't hold this information for me and at some later point in time try and upsell me another house. That's not the purpose. You have to delete it. But there is a further nuance to this in this law, which is essentially something like an automatic erasure. That after a certain period of time, that you are required to delete this information if the data principal has not come back to you and used it. Like, let's take, for example, I'm on some social media app and I'm creating videos. And then I stopped creating videos. I grew up and I didn't want to create these videos anymore. And then 12 months passes and I haven't created a video for 12 months. And let's say that the period of time is 12 months of inaction. Now the company has to go back and say, look, whatever data was being collected as a result of this, whatever permissions I got from you to use your camera and to use your microphone, I now have to basically I have to stop that provision. Or if there's data that I've collected, which is in relation to providing you a particular feature, you haven't availed that feature for 12 months. I now have to delete all that information. This is, I love it. I mean, quite frankly, if you ask me, this is operationalizing what is the implicit meaning in what we've said, right? Because essentially, don't hold data for longer than it is required. What is happening in India now is it's setting a stopwatch. And companies, big and small, and I think the big companies, as always, will be able to deal with it without a problem. The small companies, it's going to be extraordinarily less because they're going to now have to think about creating some process by which they start counting from the last activity. And then 12 months after that last activity, and I'm making this up, it could be 12 months, it could be 12 years, I don't know what it is. But there is some period of time after which they have to now start going back and deleting one day at a time data that was created 12 months ago. And that's not, it's a non-trivial thing to do when you're engineering a system.
Yeah. I want to sort of now come to another provision which, is the rationale of it is a little difficult to gauge, which is that the government wants to, on the basis of recommendations of the Data Protection Board, can now block access to information, websites, etc., etc. Now, the Information Technology Act already gives the government this power. We have, I can name it Twitter fighting it in Karnataka High Court. That has creeped into this sort of bill as well. How concerned should we be about this?
Yeah, look, I mean, I find that provision the most inexplicable in this draft. It was not there in any previous draft. It's never been discussed. It's also very broad and in its breadth is not limited to personal data. It just is, access to, deny access to any computer resource that is generating or has stored any information. So it doesn't restrict it to personal information. So it seems completely out of place in a law like in a law that is supposed to protect personal data. So I'm in my head trying to figure out what could have been the intention. And just to be charitable, I would imagine that one possible mischief that it was intended to sort out was if someone has created a website and they are publishing personal information without consent. Certainly, I think the government needs to shut that down. And so a blocking order to such a website where it is publishing in sort of a public access kind of a way personal information of one or many citizens of the country, there should be a right to shut that down. But I don't think that's what this is saying. Maybe that was the intention, but this is much, much broader, and this sounds like just a general blocking provision. So one, for me, it is out of place in this law. This is a law to protect personal data. If you look at the statements of objects and reasons, I went through all of that, and I could find no way in which this particular provision could be squeezed into that framework. Second, we've actually got other provisions of law that address this mischief. And so to have the same remedy in multiple legislations is actually not good for the country. It creates uncertainty. It doesn't contribute to the ease of business. I don't know from which side I'm going to be slapped. If I get a blocking order under the IT Act or the new Digital India Act when it comes, I don't know if tomorrow I'll get another blocking order from this act, and that's really not the correct way to operate when you're looking for ease of business. So I would say that would be my big concern with this.
Okay, the practical difficulty, or rather the remedy that now the government has given itself, even under privacy law, to block access to some of the information. And what I find interesting here is that there were news about government institutions publishing, or rather their sites having passport details, Aadhaar details of citizens. But interestingly, this version of the bill says that the government and its agencies are exempt from prosecution under the law.
Well, I don't think it says exempt from prosecution. I think it says there are certain
Good
grounds
faith.
under which they could exempt
Good faith, right? Now, good faith is like a very motherhood sort of word in that sense.
Yeah, a lot of our legislations are apple pie and motherhood. So that's we have to basically the point on the exemption is, look, I think there are some of those provisions are completely legitimate, right? So in order to process, if you have to process information in order to pursue a legal claim, or if there's like a statutory authority that's required to enforce a law, you can't now prevent that statutory authority from enforcing the law because they're processing personal information. There are a whole bunch of things which are completely legitimate. But I think subsection 2 is a little broader. Now, the breadth of that refers to all those things that we see from the Constitution down, which is integrity of the country, security, public order, all of those sorts of things. It's not uncommon for those sorts of provisions to be put in legislations, just as it's not uncommon for legislations to be struck down because they have those provisions and then they've been used in a completely arbitrary manner. So I think what we're going to need to do, I don't think these provisions will be struck down as is, but everyone needs to abide by the Puttaswamy test, the test in the 9-judge privacy bench. And so we'll have to see how these things are implemented. I think at this point in time, just having that provision there is not, the mischief has not yet happened, but we could see where the mischief happens, how it happens, etc.
Yeah, I mean, you would think that a law that has taken such a long road of consultative process, these surprises or these googlies will not come in the version that's about to become law. But one could only hope. Two final sort of points or aspects that I want to discuss with you, both of which I think you're sort of largely happy with. That the Data Protection Board will work as a digital office, and so will the appellate forums. And the sort of consent manager, entity that was there in the earlier version as well, but now it's been recognized in some fashion in terms of registration, etc.
Yeah, look, I really like the digital office thing. I've been saying for a long time that one of the ways in which we can unclog, uncongest our dispute resolution process is really with these sorts of innovations. I've written in the past about online dispute resolution. I've written on numerous occasions on using a techno-legal approach. So all of that is actually mentioned up front and center. They've actually used the word techno-legal in the law. This is the first time I'm seeing that in a draft law, so I'm really happy with that. And I'm saying this because just because we're talking about data, we're talking about personal data, the volume and velocity of information is going to be of such a high magnitude that there is, quite frankly, no other way to do this. You have to create digital offices to run. And the interesting thing is, even the
What does
appellate
that
board,
mean to create a digital office that everything happens digitally? Is that what
everything.
it
And
is?
look, I mean, quite frankly, I'm really curious to see what the data protection board does with this, because they have a blank canvas. If I was, architecting some of these things, I would just go wild with all the things that we could do. We could just have completely non-oral hearings. Why do people need to win a case because their advocacy is good? It's not required in today's day and age. Why don't we just submit briefs, have everything go asynchronously by paper, and find resolve the dispute also just in writing. We can scale that really efficiently. We can actually, these are all digital systems, and so evidence no longer needs to be adduced in the traditional way in which evidence is adduced. We can just go into the innards of the system and figure out from the system itself what the evidence is as to who did what. Why can't we think in that manner? So I keep saying that, look, we have to allow for this to happen. When we allow for this to happen, believe you me, there are going to be innovations in evidence, in this dispute resolution that will blow your mind. And I'm really glad to see that we've made a start here. Of course, what would be the worst of all worlds is if we have a digital office, but the person who's running the digital office decides to do it completely in the way that we've done it for the last century. That would be very unfortunate. But I'm hopeful that we've got an option to do something good. And then, on consent manager, that of course, we're now reaching the end of India's G20 presidency, and you and I have spoken about digital public infrastructure a lot. So the consent manager and all of these frameworks are very much integral to that conceptualization. And of course, we've had the reference to the consent manager from almost the very first Sri Krishna draft, but they've always referred to the consent manager as a type of data fiduciary. Now I see them almost putting the consent manager as a separate institutional entity in the whole framework. And so I think that actually gives it some credence and credibility. It's also, now the consent manager is not just anyone standing up and saying, look, I want to be a consent manager and manage your consent. You need to be registered with the data protection board. So it's giving it some sort of imprimatur, as it were, of a supervisory regulatory authority, which is also making it a little more serious. I like all of these kinds of innovations that we're seeing in this draft.
All right, Rahul, Matthan, we'll leave it here. Always a pleasure to get insights from you on the progress that we are making or not on privacy law in this country. Thank you very much for joining us with your initial thoughts. And in the weeks to come, as we examine the fine print of this bill more, we'll keep coming to you with expert insights. Thank you so much for joining us here on the fine print.
Thank you. My pleasure as always.